Does he have to go through all these layers, which I have to go through, but still the popular perception is that every other institution has layers of accountability and I have none. He made this brief speech and sat down, which led to a very interesting debate on this subject. And I think a lot of these issues which we are raising today really are arising out of this whole environment in which we are living, where we have created a suspicion about every acts of government which are elected, which have popular responsibility, which are accountable, and therefore other institutions, whatever they do, would be not tested on the same measure on which various acts of governance and those involved in public life, political life are going to be tested. Let us just see what really has happened. And before I come to this much discussed single point directive, or let us just start with this. There's a very salutary rationale behind it. Mr. Lal Bahadur Shastri was the Home Minister. Grants for the Home Ministry were being discussed. And the issue of accountability of civil service, issues of corruption came up. A committee headed by Mr. Santhanam was appointed. That committee consolidated all the regulations, and those regulations in 1964 came to be known as the Single Point Directive. And the rationale was that those who are in serious decision-making positions, those who have to exercise discretion, those who have to take vital decisions, can frequently be the target of frivolous complaints. Do we allow those complaints against them to go on and those people to be subjected to all this, or do we have some screening mechanism that the serious complaint will be allowed to be investigated, the frivolous complaint will be thrown out? And this is how the Single Point Directive was born. And in 1988, they replaced this senior civil servants in decision-making process by saying joint secretaries and above. And if you were to say that there is no protection to be given to you, you take all the decisions, you make all the discretions, and anybody can file a complaint and an inspector of the CBI or the police can raid your house any moment. And if this elementary protection is not to be given to the senior decision makers, you may well have a governance where instead of tendering honest advice to the political executive, a very safe, non-committal advice is going to be given. Well, these are different views of the subject. The minister may well take his own decision in the matter, because I don't want to be subjective of all these complaints. It's very easy for those who have lesser ideas of how governance really works to realize that what kind of protection is to be given at what levels. The judiciary, and let me say this in their favor, is fully conscious of the problems which may confront judiciary at all levels. A magistrate, a very junior magistrate, a civil servant, may well decide something against the local police and be the target of investigation. So the judiciary very rightly said, even though there is no law, there is no single point directive in relation to courts, the judiciary said, we can't allow such a situation to develop. So even before you register an FIR against a judge, he may be the judge at the lowest echelons of judiciary, take the permission of the Chief Justice. Before you investigate it, take the permission of the Chief Justice. There are several cases. I was going through some. In Justice Veeraswamy's case, Mr. Sibal had argued that matter. The Supreme Court said, well, against a judge of the High Court, you can't register an FIR and investigate the case till you take the permission of the Chief Justice. Otherwise, you will be opening a situation where an inspector of a police or an SHO will walk into a judge's house and say, well, I want to investigate your assets. Perhaps the judiciary knew what the problems which confront the judicial system, and therefore they rightly, even though there was no single point directive, no law, they rightly gave a judicial directive that let's start protecting judges. I was going through one of the...
I just want to inform the members of this House. What happened was that the Veeraswamy's case, when it was argued, related to a Chief Justice of the Madras High Court, who was sought to be prosecuted under the Prevention of Corruption Act. When it came to the JMM case, because in Veeraswamy's case they said that sanction is to be obtained from the Chief Justice of India before you prosecute a judge of the High Court. When it came to the JMM case, namely where members of parliament were involved, I told the court that you have the same provision where there is no sanction to a member of parliament, because the sanctioning authority has to be the appointing authority. And a member of parliament is not appointed. A member of parliament is elected. And the sanctioning authority has to be the removing authority. A member of parliament is not removed by government. Therefore, under the Prevention of Corruption Act, there is no sanctioning authority, just as in the case of a judge, because the judge can only be removed through the impeachment process. He can't be removed by the government. Therefore, the same principle must apply. So they applied a different principle to their own kin, but didn't apply that principle to members of parliament. Now, what's the logic? I just wanted to place this on record.
Different yardsticks.
Madam, therefore the judiciary, when it came to judges, very clearly said in Justice Veeraswamy's case, and I'm just reading one sentence, we therefore direct that no criminal case shall be registered under section 154 CRPC against a judge of a High Court, Chief Justice of a High Court or a judge of a Supreme Court unless the Chief Justice of India is consulted in the matter. Then came, this is for judges of the High Court, Supreme Court, what do you do about magistrates, etc. In one case, the magistrate was charged with bribe. So even if he was charged with bribe, the judiciary said, we direct that in addition, no crime for investigation should be registered pursuant to any FIR without the permission of the Chief Justice. So the judiciary, and I support these decisions, because otherwise it will lead to a very strange situation that you may well have an inspector of a police says, well, you don't have an immunity against investigation. If it comes to a question of sanction, I'll see who's to be consulted. I'm first raiding your house. I'm searching your house. You passed strictures against me yesterday. We'll settle that issue separately. Therefore, the judges were rightly entitled to this protection. And then you have a whole history. Right from 1964, the committee, Santhanam committee report, that those in decision-making positions in government, can they be allowed to be investigated for every discretion they have exercised, or should there be some screening mechanism which must see whether it's a frivolous complaint or it is some matter which requires investigation? Now this process continued. And when this process continued, and the last of these directives were issued, what happened in one of the offshoots of the Hawala case, where the single point directive was struck down? The principal reason the single point directive was struck down is not that single point directive itself is void or the whole concept is obnoxious. The principal reason was, and here I am quoting, in the absence of any statutory requirement of prior permission or sanction for investigation, it cannot be imposed as a condition precedent for initiation of investigation once jurisdiction is conferred on the CBI to investigate the offence by virtue of Section 3 of the Act. Now, Section 4 of the Delhi Special Police Establishment Act said powers of superintendence are given to the central government over CBI. So the central government at that time defended, well, because we have powers of superintendence, the power of superintendence will include the power to tell the CBI that don't investigate a senior officer without taking permission of the central government. They said, well, the meaning of the word superintendence does not bring with its ambit such a wide power, and therefore under the Special Police Establishment Act, you do not have the statutory power to tell the CBI to ask you. But what should be the statutory power? And this is my principal reasoning. What should be the procedure for this? Madam, who is to decide this? Is it to be decided by this House pursuant to its legislative jurisdiction, or is it to be decided by the judicial institution? It's a matter of policy. The policy has to be given a legislative shape, and when policy is to be given a legislative shape, the sovereignty of that belongs to this House. It does not belong to judicial institution. Members have occasionally said that of late we first started with public interest litigations. I am not opposed to them. Where executive doesn't perform its duty, please, there must be an active public interest litigation. The next stage has been judicial legislation in terms of directions to maintain one of the basic structures of the Constitution, which is separation of powers. It is this tendency which we have to make sure that statesmanship, both by the judicial institution as also by the legislative institution, that legislative policy and legislative power will have to be decided by the House. Therefore, if this House feels that a single point directive is not necessary, if a joint secretary or a secretary government of India takes a decision and the inspector of the CBI is entitled to visit him without anybody's permission, then what are the consequences of it on governance going to be, on decision making going to be? It's a serious matter which really should be considered. And the government is of the very considered view, as also the committee which has lent its stamp of approval on this, that in such matters there has to be some preliminary screening. If it is per se frivolous, then you cannot allow senior officers at the level of decision making really to be brought into this whole process. I am conscious of the fact when people have been quoted as to what goes on. Well, we can make a lot of quotes. There is I don't get into names, there's a former chief election commissioner. About corruption, the best quotes came from him. And I do remember, subsequent to retirement, despite the best quotes against politicians, first running to my friends in the Shiv Sena to get nominations for one political office to be proposed, and then running to the Congress party for another nomination. We had
all very well. We were only wondering that there has to be some safeguard. So the alternative that was suggested was that where the central government refuses to allow an investigation, at least it must give reasons in writing which will ultimately on occasion be tested in a court.
Well,
there should be no objection to that.
I think what comes from Mr. Nariman is something which I cannot even argue against. Because if the central government says on basis of these facts, permission is being granted or is not being granted, these orders of the central government must necessarily contain reasons. They can't be. That's not in the law. Well, Mr. Nariman, with utmost respect, if I may just say this, it is obvious that when governments pass these orders, they'll have to be reasoned orders. These orders would also be tested on judicial review. Reasoning will have to be given, and if the governments choose not to give reasons, these reasons would be struck down for the asking, as there being no reasons at all if you have no reasons to give. And I'm sure my friend Mr. Pathak, while responding to this, would also repeat this assurance to you that in these cases reasons would necessarily have to be given when somebody asks for a permission and you deny that permission to him. But let us just see this. To what extent we will take the distrust. I recently came across a statement of one of the most eminent persons in Indian public life. India's foreign exchange reserves are increasing because Indian politicians have started bringing monies back from their Swiss accounts. Now, $85 billion, we must have an idea what $1 billion is. Are we going to take distrust against politicians to such an extent that, well, whatever power is to be given to them, necessarily will have to be viewed with some element of suspicion? Madam, the question has been raised as far as the question of MPs is concerned. It's for my learned friend and his department and then collectively the government to take a view. But my suggestion would be that at some stage either a discussion on this subject or an all-party meeting on this subject can be held, because it may be very difficult for us to suggest that MPs must have no accountability. There'll have to be some forum of accountability. But what seems to have happened in the past is that when the 1988 Prevention of Corruption Act was brought in, a question was specifically raised in Parliament as to whether MPs are public servants or not. The Minister for Personnel at that stage, while piloting the bill, said, no, you are not public servants merely because you are MPs. If you are holding some other office as to chairman of some undertaking or something, you may be public servants because of that, but by virtue of being MPs, you are not public servants. But on the ground that the definition of a public servant, as in the penal code, includes a person who performs a public duty, the Supreme Court interpreted it. The Supreme Court interpreted it to say that because a member of parliament performs a public duty, he is necessarily a public servant. And then this whole debate has now started as to whether, being a public servant, who should be the sanctioning authority. The first instance, the view was there is absolutely no sanctioning authority. The alternate view given is that if you don't have a sanctioning authority which is defined in law, let the Speaker of the House or the Chairperson of the House be the sanctioning authority as far as you are concerned. Now, these are again, if I may suggest, arrangements for sanctioning which have been made by judicial construction. These are all matters really which has to be sorted out eventually by legislation. And I would suggest that at some stage, formally or informally, if the Department of Personnel consults all parties, some layers of accountability would have to be maintained. What those accountability mechanisms would be, what those procedures would be, is a matter which we can separately discuss. Thank you very much, Madam, for having permission.
Thank you.